Okay, so today we're going to talk about I found a buyer. What do I do now that I have a buyer? So the first thing we want to do is get the buyer under an agency contract. And I'm just going to kind of bounce through this. And if you got questions, just stop me if something doesn't make sense. I'm going to tell you how to fill in the blanks and pretty much what the paragraphs mean. I'm not going to read them word for bloody word, but buyer's name goes here. And then Keller Williams, Greater Springfield goes here. It doesn't have to have Greater Springfield, but Keller Williams goes here because when they sign this document, they are hiring the Keller Williams brokerage as a whole. And then the brokers, either Jim or I, will designate you guys to be the agents to work with this particular client. Hello. How are you? I'm well, thank you. What kind of property are we looking to buy? Commercial, residential, rental? So if you've got land, you'd have to check this box for other and put land in this blank. If they're looking for multiple things, you can check multiple boxes. So if they want a residential and a rental and land, you can put all that on there. Now, when your buyer signs this document back here on page 4, this becomes the effective date that this contract begins. This is the date that your employment commences. This date here on page 1 is the date that this agreement expires. So if I was going into a 6-month agreement with this particular client, gotta make sure I'm doing that right, would be the 4th day of July 2023. So that would be the date that this expires. And I'm going to do everything I can to try to help you acquire property during this time period. But also, Mr. and Mrs. Buyer, you're going to refer all inquiries and prospects that you may receive during this agency period from any source to me to avoid the possibility of confusion over any agency relationship or misunderstandings for liability about compensation. So you're hiring me for a reason. Make sure everything goes through me. If you get a lead somewhere else or go to an open house, that's fine, but let me know, because I want to communicate with that other agent so they don't believe that they are the ones representing you, because I am the one representing you. So allow me to do that. Motivating factors. Does the client care if you tell people why they're looking for a house? So, maybe it's first-time home buyer, but if they don't, you can check does not, and you can leave this blank. You don't have to put anything in here, but if you check does, you must have something written in this blank. All right, current representation agreement. 99 times, if not more, out of 100, your client will not be working with someone else. So you check is not, and you can move on. But let's suppose that this client called you because you didn't call my client, because that would be crossing my sign. Let's suppose my client called you and said, hey, Don's not doing a great job. He hadn't found us a house. We don't feel like he's working for us. Will you take over as our buyer's agent once his agreement expires? You can say, yes, I'll be over this afternoon. So let's assume my agreement expires on 1/31/2023. So you cannot be that person's agent until after my agreement expires, or unless they cancel me and I let them out, which I would, because I don't want to work with somebody that want to work with me. But I indicated that right here is the date that this agreement begins. So you can still have the upcoming client sign in date here. And then you're going to scroll back to section 9, and you're going to make your effective date 2/1/2023. That's the date your employment begins, because you cannot be employed by this client because I am currently employed by them. Once I am done, you can officially take over. But you can go ahead and get this signed such that you are in that position whenever mine expires. Now, you shouldn't advise, consult, direct, or anything while they're under an agreement with me, because that's still my job. But you can be in that position to start doing some research for them. And maybe on February 1st, you've got a list of 6 houses you can go show them. Okay. But again, most of the time, that's not going to be the issue, because they won't be working with somebody. You can check is not, and then just come on down the road. All right, realtor fee. This is where we get our nuts and bolts and how we get paid. If you are charging a transaction fee, so let's say you've hired Onward Agent Services for the $250 for every transaction, and you're going to charge your client that $250 in order to help cover your expenses for your staff. And that's how I would explain this to someone. This is what helps with my marketing, my staff, the photography, all of the things that are outside of my compensation, which is the commission that I earn. These are the extra expenses that I incur to try to market you and your property, or your property, and get my paperwork done in the right manner. If you collect this amount, you have the option to either collect it the date that this contract is signed, the date that the other compensation down here is collected, which would be at closing, or if you've got 0, then you'll check not applicable. I would tell you to get it the date of closing, because then it'll be on the settlement statement and you'll get your check cut that way. If you get it the date that this contract is signed, the check has to be made out to Keller Williams. We do not have an escrow account. I'm not going to require the staff to go cutting $250 checks every time somebody gets a buyer. So you're going to have to hold it till closing anyway. So rather than risk losing the check, I would encourage you just to get it at closing. All right, I don't like the way this is phrased as additional compensation, because this is how we actually get paid. So if you're doing a flat fee of, $5,000, you write out 5,000 and then you'll write the number 5,000 here. I would tell you, if you're not doing that, just to go ahead and put zeros in both the blanks, just so it's clear that we're not doing that. I think you've all attended one of my classes, so you know I can't price fix you as your broker and tell you what you can and can't charge. However, here's what you will typically see. I'd be fine with that if you guys had 4 and 5 on there, but this commission, because we are just representing the buyer, only has to pay my fee. If we were representing a seller, I'm going to have to pay my fee and a buyer's agent's fee. This is just for the buyer's agent. Now you're going to get buyers. They're going to say, whoa, 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 whoa. I thought the seller was paying for my my commission. Well, look right here at line 33, Mr. Buyer. You understand that I'm going to endeavor to collect part or all of this additional compensation due to me from the seller or listing broker. But this is also the point to have the conversation that if the MLS, which you will see, we talked about this earlier a couple times today, when foreclosures and the REOs start coming, banks don't offer a full 6% commission. Normally it's 5%. If sometimes it's even less than that. So on the MLS, it's going to be a published fee of 2.5% in that example. Your buyer has agreed to 3%. So one of two things has to happen. You've got to come back and amend this agreement and knock it down to 2.5%, or your buyer's got to make up that additional 0.5%, because you are entitled to 3 as per your contract. Okay. I'm going to do all I can to collect this from somebody else. And then also, Mr. Buyer, if our agreement expires as of whatever day we said, the 4th of July, I didn't even realize that's what that was. If you declare your independence of me on the 4th of July, and you end up purchasing a property, and I personally use 90, I know a lot of our big teams use 180 days, but if you end up purchasing a property in the next 90 days that I showed to you while I was your buyer's agent, I am still entitled to my compensation. Now, if that buyer goes out on July 5th and hires another agent, I'm out, because they now have representation. The protection period is built truly for us agents to keep buyers and sellers from saying, hey, his agreement expires on Tuesday. Why don't you just wait? Then I'll sell it to you directly. We can both save the commission. I don't have to pay as much and you don't have to spend as much. That's why it's built in. And I would tell you, don't go open a bank account for all the protection period money you're going to make over the years, because it's hard to track. It's hard to keep up with. And the only way I've ever found out over my career is another agent being honest and calling me and saying, hey, Don, we just wrote a contract on 123 Main Street. I think it may be the person that you showed 3 weeks ago. Okay. So it's hard to keep track of. See if there's anything else that you guys need to know. And it says that we can cooperate with other brokers as per our MLS. If you do collect your flat fee of $250 or whatever at the beginning, so if you do collect this up front and you've got the check in your hot little hands, and for whatever reason the buyer flakes on you, you have the right to keep that money. So that would be the only reason I would tell you maybe to collect it up front, is if you're doing a lot of legwork up front and the buyer flakes on you, at least you've recouped some of your time as far as expense is concerned. When we enter into this agreement with the buyer, we are a buyer's limited agent working with the buyer's best interest at heart, essentially only for the buyer. Mr. Buyer, I would like the opportunity to work as a dual agent if that opportunity presents itself. And I explain that this way. Well, I also bring them back to page 5, down to the dual agent duties, just to show them. Here's what I can and can't do as a dual agent. I can't tell them that you're willing to take more, the seller's willing to take less, what the motivating factors are for either of you, financing terms that other people, that either party might accept. And I also can't tell you, Mr. Buyer, about any other offers the seller may have received. And I go on to describe it that imagine a room that's got a giant wall down the middle and a door right here. You're on this side. The seller that I have found through my marketing is on this side. You are already my client. The seller comes along. I can't divulge any information from you to him or from him to you without permission from this side of the wall. So nothing can go through that wall without the permission of each party. And this is personal to me. This is not something that you guys have to do. This isn't a broker instruction, but I also always tell, like if I'm working with this buyer, I will tell them, you are in first position. You are my client first. If I happen to find a house that works perfectly for you, and we reach an agreement, and we have a contract, if you ever feel like I'm not fully representing you, you tell me and I'll refer that listing out to someone else in my office and they can take that over. That's just what I do. It puts them at ease every time. I've never had a problem checking on the dual agency. Transaction brokerage. If you haven't taken my class, you'll hear me sigh every time about this. Transaction broker means that you can't advise, consult, direct, give your opinion or anything. I can tell you what needs to go in this blank and I can fill in the blank for you. I can't give you my thoughts about what should go in that blank. I can explain the contract to you, but I can't tell you what you should do with that information. And technically, until you have this document signed, that is how you were supposed to be operating. I will tell you that none of us do that because we are all here to help other people by nature. But when we entered into this, we were a buyer's limited agent doing all those things, advising, consulting, directing, giving our opinions. So A, I think it's impossible to be a transaction broker, but B, I think it is virtually impossible to go from a caregiver to a paper pusher. And that's the way I explain it to them is, you want me to do more than a transaction broker and I'm going to. Now, on the flip side of that coin, if you happen to get a friend or a seller that calls you and says, hey, I had a garage sale the other day. The neighbor came up and said he really wants to buy my house. We already reached an agreement on numbers. Can you write it up for me? Absolutely. Call me and I will walk you through the way to do that so you can still have agency representation without being really a party to the transaction. Okay. Buyer's obligations to the realtor, and I like talking to my agents or my clients about this. 1 and 4 are very similar. It says you're going to work exclusively with me. You're going to consult with me before visiting any new homes. You're not going to communicate directly or indirectly with any other agent, which it says down here, or contacting. I don't want them contacting anyone. For the purchase of operating exchange, to avoid the possibility of confusion over agency relationships and misunderstanding. I go back to everything goes through me. You're hiring me for a reason. Let me do my job. Also, Mr. Buyer, the seller's going to want to know how we're paying for this house. So either we're going to have a proof of funds, we're going to have loan information. And with that loan information, the lender may be requiring information from us. We need to provide that in a timely manner to make sure that everything is happening. Line 3 is my favorite line that's been written in the 20 some odd years I've been working as a realtor. Be available during my regular working hours, whatever the heck that means. So I take the opportunity here to have the conversation with the buyer that says, how do you want me to communicate with you? In what fashion? Mail, email, phone, smoke signals? How often? Don't ever let them tell you every day. Unless it's a really hot market and there's new property coming on every day. But find out, because if they expect to hear from you every day, okay, I'll reach out to you every other day and once on the weekend. Because if they expect every other day and you reach out to them on the 3rd day, they're already mad at you, even though you may have the perfect house for them. So set those expectations up front and going into it. Mr. and Buyer, we're going to look at all properties regardless of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, gender identity of the owner. If you choose not to look at any of those properties, please go find someone else to represent you because I cannot legally do that. Notice of intended sale. I'm going to make sure that the seller either pays off all of their invoices or has all their invoices to the title company so you don't get saddled with a lien when we close this property. Legal and professional advice. I am a realtor by trade. I am not a law, tax, finance, survey, structural, mechanical, hazmat, engineering, or any other specialized topic. If in this transaction, we have the need to seek out the advice of any of those people, I'm going to encourage you to go ask them those questions. If you don't have those people, I will help you find them, but I'm not going to be the one answering those kinds of questions because that's not my expertise. Default and remedies. We are going to get along fantastically throughout this transaction. But in the event we don't, and I have to come after you for my compensation and I win, you're also going to pay for my reasonable attorney costs. Other provisions. I never like to use my clients' words against them in any shape or fashion. But if my client says we're only going to look at houses with cul-de-sac, you guys get the idea, I'm not going to spell it right, or a pond or a pool. I don't even have my fingers in the right place, but you get my point. If they're giving me any kind of specifics, number 1, I'm going to write them down here so I don't forget them. Number 2, it shows that I'm paying attention. And number 3, when they call me in 2 weeks and say, we just drove past 123 Main Street, it looks perfect. Why haven't you called me? Because you drove past it on 123 Main Street. It's not in a cul-de-sac. If that's no longer a deal breaker for you, we should revisit that. But that is the reason I didn't send you that property, because you told me you wanted a property in the cul-de-sac because you got kids and you don't want people driving by the house. Okay. And a lot of times I will dig deep on why you have to have a cul-de-sac, or what if we find you the perfect house with the perfect backyard? Would you be willing to put in a pool? Or, you know, whatever the case may be. I dig down on those objections to make sure that they're real, because a lot of times they're not. Minimum brokerage services. This is what the statute says we're going to do. Mr. Buyer, I'm going to do so much more than this, but I'm at least going to assist you with the delivery and presenting of offers. I'm going to help you develop and communicate and negotiate offers, and I'm going to answer questions about those offers and counter offers. Duh, we're going to do so much more than that. Thanks to the fantastic Missouri Uniform Electronic Transactions Act, you and your client can be anywhere in the world and sign this document, and it's valid. It is only valid in the state of Missouri, but it is valid from anywhere in the world. Franchise disclosure, you will check this box because we are a franchise, and in the event that the buyer chooses to sue, they can only sue this office. They can't sue the entirety. Effective date, we talked about this. Really, the only reason I see that you would ever need to use this is if they're under agreement with someone else. Because to me, well, we don't really want to look till March. Okay, well, I tell you what, let's go ahead and get this document signed so I can start working for you because you never know. The perfect house might come up on February 27th. Let's talk about your parameters. I won't push you till March 1st, but at least let me have my systems working in the background in case the perfect house comes up. Okay. KW goes here, your signature, your printed name. This document, I don't think you get compliance if you don't have your email, your address. I don't care about your title. Make sure you've got a date on here. Same thing with the buyer. I usually do try to capture the buyer's email here as well as their address. And this is just because I'm old and been doing it for so long. I always knew that I could come to this document and find those two things if I needed them. Find their phone number, their email, and their home address. I always put it on this document for that reason. And then here at the bottom is where I was talking about when they sign this document, they hire Keller Williams, the brokerage. Then you will in turn come in and put your name in this blank as the agent that's going to be designated to work with this client. If you're a solo agent, it's just you. If you're working with someone else in tandem, both of you go on here. If you're on a team, every licensed member of that team needs to be listed here. And a lot of the teams now just have a C attached, and they've got, you know, the 30 people that are on their team all on there. But you have to designate everybody that might have an opportunity to talk to that client other than Jim Boland or myself. And then you'll send it to us and we'll sign and date it here. And then the last two pages are buyer's limited agent duties, dual agent duties, and then the transaction brokerage is the last page. All right, I bounced that pretty fast. Did that make sense? Everybody get that? Everybody good? Everybody go sign a buyer's agency agreement today? Excellent. Okay, now let's get on to our residential. So we've gone and we've looked at a property and now we're ready to make an offer. Fantastic. Let's make an offer. Buyer's name goes here in the top blank. And you will have some buyers that have been around the block, so to speak, and they're going to say, well, why isn't there a seller's name on there? Because our old contracts actually used to have a seller's name on there. They're going to say, why isn't there a seller's name on there? Well, because there doesn't have to be a seller's name. The only individual or individuals that can convey the property at this particular location is the person that owns it. We are making an offer from this buyer to purchase this property, regardless of who the ownership is. So there doesn't have to be a seller name there. I'm making an offer to purchase this property. If the property is located within the city limits, put the city here, whether that be Springfield, Willard, Nixa, whoever it is. If it's within the city limits, put the city there. And then otherwise just city, zip, county, and zip there. Check box of legal description. I'm going to tell you to leave this box unchecked because if no legal description is attached, then legal description on seller's vesting deed to govern. So what does that mean? That means it's on the title company's shoulders and not yours, which helps limit your liability, which is one of your broker's main goals, because the less you have liability, the less we have an opportunity for you guys to get sued. Inclusions and exclusions. Note, this contract and not a seller's disclosure statement, MLS, or other promotional material provides what's included in this sale. If it's not within the four corners of these 8 pages, I cannot defend it. You can't tell me, well, the MLS said there was a refrigerator. If it's not in this document, it does not exist. These are the things that the buyers should relatively expect to come with the property. Please note a couple things we need to pay attention to here. Propane tanks, solar panels, and to a lesser extent, water softeners. So on inclusion, so if we want the TV and the tractor, we can ask for those things, but then I'm going to tell you to put of no value after it because lenders don't like stuff. They don't want a loan on the TV and the tractor in the house. They only want a loan on the house. And some lenders will require you to take that out of there. And also keep in mind, if there is a reserve item on the MLS, like the chandelier in the front lobby, you can still ask to have that be included in the property. Exclusions would be, oh, sorry, we got this double screen thing going. Sometimes I lose my mouse over here on this other monitor. So let's suppose the propane tank is leased. So the propane tank is going to be an exclusion because it does not convey with the property. Now there's a decent chance you could get with the same propane company, have the tank never moved, have the gas never removed and or replaced, but your buyer does not own that tank and it cannot be conveyed with that property. If there is a play set in the backyard, I had one 6 months ago, somebody had a giant wooden train that they had erected out front of their house. Like, can we ask to have that removed? Like, absolutely. If you don't want it there, make them get rid of it. All right, purchase price and earnest money. This is pretty straightforward. So we're going to offer $100,000 on this house. Seller concessions. A lot of times people are like, what does that mean? Well, it says right here, see section 10. So what do? I bring them right back here to section 10 eventually. And it talks about what adjustments and closing costs are. And this is one of the changes to the contract that has been made in the past 2 weeks, is they've gone in and they've added some things that the title company needed specificity for about who's responsible to pay it, because there was some gray area about who was responsible for these things. And the title company were getting pushback because it wasn't included in the contract. Buyers were saying, well, I wasn't told that I was responsible for that, and vice versa. So they've added some extra things in here that I'm not going to bore you with about what's in there, but it was really added more for the title company's benefit to really designate those expenses where they're supposed to go. But your buyer is going to be responsible for all these items from 279 to 288. And then the seller is going to be responsible for all these items from 289 to 294. And then both parties are going to prorate the items from 295 to 298. So if I ask for, oops, wrong way. If I ask for $2,500 of seller concessions on page 1, that $2,500 first comes right here and pays all of these items that they can. And then it skips right here because the seller's already responsible for these. So if I've got money left over, then it comes down here and pays for whatever I can down here. And then if there's money left over here, the seller gets it back. It's rare that you won't use up all your concessions, and normally the lender is going to tell you what you can and can't ask for and what you should ask for, etc. Normally you'll use all those up, but if there's any left over, that goes back to the seller. So I also have this conversation, and I should just show you this, guys, right while we're here right now too. Seller concessions, also they can do this, they et cetera, but they cannot include other expenses, or excuse me. Yep, I need to make sure I'm not getting you guys confused here. Could change this just a little bit. There's this. So the seller concessions can include anything that is required by the buyer, the title company, the buyer's lender, but they cannot include the cost of a home warranty, the title fees paid by the seller, these items right here that they're already paying for, or any transaction fees. So if you're charging $250 to your buyer is responsible for that. That does not come out of seller concessions. I was going somewhere else with that, and I lost my train of thought, but that's all right. So if they need it, ask for it. If they don't need it, then, you know, I wouldn't, but that's up to you. That's truly a case-by-case scenario with your buyers as to what they need and don't need. Earnest money. I have mixed emotions about earnest money. I always tell my clients, especially if there's not a super hot market or whatever, I'm like, we're not going to offer it unless they ask for it. If they ask for it, we're absolutely going to give it to them to show them that we're serious. Now, I flip that script a little bit because at times, if I've got a property that is fresh on the market and I know I'm going to have competition today, but we're going to make an offer, I'm going to go ahead and offer earnest money to show that we're serious. So I do that if I know I want to do that, or if I've got a buyer that's like, you know, we want to make sure that they know that we're serious. And you'll get some folks from like California, well, it's not a valid contract if you don't have earnest money. It's fine. But this is, again, do what your buyer wants to do. I just hate getting earnest money tied up, because I think right now I've got 3 going on that are in dispute because the buyer wants it back. The seller doesn't want to give it up because the contract's gone south. So it just sits there and everybody fights about it. So that's the reason I try not to offer it unless they ask for it, because I don't want something to go south and then my buyer's 500 or $1,000 is tied up over here. And that's the other reason I don't offer it, is I don't want to just give your money away if we don't have to. You're going to end up spending that $500 or $1,000 at closing anyway. But if we can keep it in your bank account till then, I'd rather do that. Okay. So if you do collect it, who's going to hold it? Again, we do not have an escrow account here. So odds are it's going to be at the title company. No later than 5 days. Here's 2 sentences that scare your broker to death. And I was really hoping this was going to be changed, but it was not. If earnest money is not timely delivered to escrow agent, your broker considers timely delivered within the 5-day time period up here. But I could interpret this: if the earnest money is not timely delivered to escrow agent, then seller may terminate this contract by providing notice to buyer at any time prior to deliver of earnest money to escrow agent. So my black hat cynic in me can see the interpretation of this. You get your offer accepted at 4:57 today. So you're not going to have an opportunity to take that money to the title company today because they're already closed. Client gets another offer at 8 o'clock tonight that's better. I can actually see this being interpreted that we could terminate your offer because your earnest money is not at the escrow agent yet. I don't like it. I haven't had that happen yet, but the moral of the story is, if you've got earnest money, get it to the title company as fast as possible to eliminate this possibility. If there's additional earnest money later on, there's a special writer you can use. Make sure you get a receipt of the deposit at the title company. You'll need that for your compliance anyway, but make sure you get a receipt, because that ends the paper trail with you guys. Again, taking the liability off your shoulders and putting it onto someone else. Where are we going to close this property? Odds are it might be at the same place that's actually holding our earnest money. Where is it? Specific location, on the month and the day and the year. Now, I've had people say, well, can't I just put to be determined in there? Well, you can, but you don't have a valid contract. I cannot have a valid contract without an end date, because there's no default without an end date. So I would rather you put, if you don't know, I'd rather you put a date out a little bit longer and call me and say, hey, I know this is a 60-day close or a 75-day close. We're trying to get a couple things in line for the buyer. We're hoping to move it up into our normal 45-day time period, but we're just hedging our bets a little bit. So if you need extra time, ask for it, and you can always extend the close date as needed. Well, provided everyone agrees. But brokers are not responsible for delivery of keys. Buyers should change the locks following possession to reset factory, et cetera, et cetera. I make sure this happens. And a lot of you guys know I actually use Mike, the rekey guy now. It's just my closing gift, because I want to make sure those locks get changed, because they close on a Thursday or Friday. The friends come over for pizza and beer and help them unpack the boxes. It's the weekend. They're overwhelmed. They didn't sleep. And Monday they're back to work. And then guess what happens 2 or 3 weeks down the road? They haven't changed their locks. And crazy cousin Eddie, or, the babysitter or the gardener, who knows who still has a key to that property with someone that's no longer in it. So I want to make sure we get those things changed. If possession is happening either before or after, please call me, because we need to talk about that to make sure it's happening right and we know that everybody's on the same page. Because I rarely, if ever, have a possession prior or a possession after that there's not an issue, because somebody is upset about something. So try to avoid that if you can. Unless specified otherwise, property will be vacant at the time of closing in its present condition, minus ordinary wear and tear, and free of debris or personal property not included above. Carpets don't have to be cleaned. The floor doesn't have to be mopped, but I want my buyer to walk into that house in what I call broom clean condition. I don't want a pile of trash in the corner. I don't want a pile of trash in the garage unless they've already asked my client, hey, can you haul this to the street on Monday where our trash company's coming? If I don't know about it, it shouldn't be there. But my client should readily be able to move their furniture in that house today without having to move any of your stuff out of the way. Okay. If there's a tenant in the property, there's a rental property writer. Again, talking about that if you've got that situation. All right, contingency. Do we have a contingency on the sale of another property? If it is or is not, are we doing an appraisal contingency? If you're doing any kind of financing, please check this box. Because if you don't check the box and your lender comes back and says, well, we can't get it because of the appraisal, you can't get out of it because of that. And I got to find the actual where it is. Yeah, if B is not checked above, the appraisal contingency has been waived, removed, then failure of the property to appraise at the purchase price will not constitute grounds to exercise the finance contingency. So if it's not checked, or if this time frame lapses and the appraisal comes back low, your client can't get out of that with a letter from the lender any longer. So on that note, I want you to carry through this time period to whatever your closing time period is. So let's assume we got a 45-day close, make your appraisal 45 days. That way, if there's an issue, we have to have it reappraised, we're still within our time frame. And then you've got, once you get your appraisal back, you've got time to actually send a notice that says we want something, if the appraisal comes back low, we've got the time to send it in. And then we've essentially got 5 days to get on the same page with the seller about what's going to happen with that. Are we going to lower the sales price? Are we going to up the sales price? Are you going to give us more concessions? I don't see any need to change this time period, because if you can't get on the same page in 5 days, we're probably not going to. It's probably just not going to happen. Finance contingency, either not contingent upon financing, we're doing a government loan, or we're doing conventional. And please note, which I hate that it's stuck over here in hiding, if you've got a pre-approval letter, that goes right here. Also, please note, even though it says not contingent upon financing, that doesn't mean your client has to pay cash. Client can pay cash, they can also finance the property, but you can't send me a letter from a lender with the finance denial and get out of it. Your client has to show up with some kind of funds to pay for the property, whether they sell cars, get it out of the mattress, whatever they do, they've got to show up with the funds, because it's not contingent upon anything from a lender. Non-conventional, I'll show you the government loan writer here in a minute. And then there's conventional. Same thing here, we're going to carry our finance time period through to closing to make sure that if something comes up in underwriting or anything like that, that we're covered through to closing. Your broker hates these lines right here, because it's talking about the terms that my buyer is getting. I don't think it's anybody's business. And I believe we've finally gotten it through compliance. You can go ahead and put your terms in there if you wish to, and you will get pushback from some other companies that say, I want that filled out. I don't push back, I fill it out. But it's kind of like offering earnest money. I don't like giving information about my client if I don't have to. So I write to be determined in all these little lines right here. I will probably know what kind of rate, what they're doing. And then I'm going to put all terms to be determined by lender. And I'm going to spell determined right when I do it, but that way, essentially I'm saying this isn't my responsibility to know what my client's terms are. This is between the lender and my client. They're going to finance that however they want to. And again, you might get some pushback that says we really want that filled in. And if so, use some broad brushstrokes. You don't have to give them specificity, but make sure that you've got that in there. And also note here, this 45 days, and I'll talk to you about this again in a minute, special agreements. If you have to extend the contract, especially because of financing, make sure you extend this time period, because if the loan contingency deadline passes without a termination, buyer remains obligated under this contract and must have available funds required to close. So if we get a notice on the 44th day that we're not going to close till the 47th day, we get notice on the 46th day that we're not going to get it, your finance is not going to go through, guess what? Your buyer's hosed. They're going to have to figure out a way to show up with funds, and or they're going to be in default. All right, title survey. Seller is going to indicate that they're going to provide a clean title as of the time of closing. Typical way this happens, seller does a title search, and then buyer pays for title insurance. Title search makes sure there's no liens or encumbrances on the property. Title insurance ensures that if something was missed, your buyer's still covered and not responsible for anything before the date of their close. This contract allows 4 different manners for that. And it says within 10 days below, the seller's going to deliver the title commitment. I think 10 days is fine. As long as you get your contract to the title company the day or the day after you wrote it, you'll have your title commitment back in 10 days. I've not had that issue, and I've not had any of the title companies tell me extend that time period because we're so behind. Okay. So A says the seller is going to pay for both the title search and the title insurance. So the example I use for this is if I've got a first-time home buyer with 0 ready available cash, and they've got to ask for seller concessions, I might tell them, okay, that's fine. What we're going to do is we're going to offer 103 on this property. And this, you don't have to do this, just a lot of times the way I will explain this. We're going to offer 103 on this property, ask for our seller concessions, and then we're going to ask the seller to fix both of these things. So then I call the agent and say, hey, we're asking for the seller to do both title search and title commitment as well as concessions, but we went over list price in hopes that you guys can get this done. Okay, just to justify what I'm doing. B says I'm going to split it 50-50. Sounds great on paper. but a title search and a title insurance are never going to be 100% equal. So someone's coming out ahead and someone's coming out behind. C is just the way I talked about it. Seller does the search, buyer pays for the insurance. And then D says buyer's going to pay for the whole thing. The example I use in this one is I've got an investor that's going to offer you $90,000 cash. We're going to close in 10 days, no concessions. And oh yeah, by the way, they'll pay for both your title search and their title insurance. That's really the only real reasons I can see to use A and D. And again, to me, B is just not fair to both parties. Who's going to issue the title policy? Most likely the same place that we're closing. You may also obtain a survey to confirm legal description and so forth. And I've got 20 days to review the title commitment after its receipt, including all other use restrictions, rights, covenants, and all other recorded documents which buyer may desire to obtain. If you are not getting a survey, I think you can leave this blank alone. Because once you get used to it, you can review an entire title commitment stem to stern in about 20 minutes. So 20 days is plenty. If you are getting a survey, carry that time frame through to closing, because surveys are not fast to get done. You're gonna have to get them booked. They're gonna have to get out there. They're gonna have to pin it out. They've got to measure it. They've got to write the report, and getting that done and back and reviewed in 20 days, a lot of times is a stretch. So I just carry that through to closing to make sure it's good. This other 20-day box down here only applies if you've checked this box D right here, because essentially what this says is the buyer is going to deliver to the buyer the title commitment, and then the buyer has the chance to review the title commitment and then make any exceptions if they want to. So we get our title commitment back, and there is a $500 lien from the city because they had to mow the ditch. Buyer says, I want that fixed. So they send this title and survey notice saying, we want this $500 lien taken care of. All parties have 7 days to get on the same page about what's going to happen. Again, I think that's plenty of time. If we can't get on the same page in 7 days, we're probably not going to. So let's suppose that we send our title and survey notice to the seller that says, we want this $500 repaired. We get a call from the agent that says, boy, you really got up in his craw, because he yelled and screamed at me and said, I told the city not to mow that ditch, and I'm never paying him that $500 no matter what. The house can just sit here and rot. Okay, so I guess the deal dies, because if the seller refuses to fix it, the deal dies. But then this little right here, contracts will automatically terminate unless the buyer within 3 days, if none stated. Again, I think that's fine. After receipts, a buyer objections agrees without correction of such objections. So if the seller, hang on, I'll make sure I'm telling you that right. Yeah, so if the seller doesn't agree, then contract terminates unless the buyer throws their hands up within 3 days and says, you know what, we'll go ahead and pay for that $500 to take care of it because we still want the property. If the seller doesn't respond at all, then they've deemed to refuse to fix anything. If the contract's terminated, earnest money goes back to anything. Seller's the one responsible for clearing title. If there's issues, then we have to do that. If there's a new subdivision writer, we've got to let them know that. Any permitted exceptions, all this is part of your actual title commitment. And it's just telling exactly what's going to be in there. Okay, inspections. This is the fun part. Property being sold in its present condition with no warranties expressed or implied. Unless waived in writing, buyer may inspect the property, have it inspected by qualified inspector on behalf of the whatever. Okay, well, what does that mean? Because we don't actually have a licensure for this in the state of Missouri for inspectors. The attorneys tell us that truly anyone can inspect this property. Your buyer can do their own inspection. It's advised against, but your buyer can do their own inspections. If the buyer is going to object to anything, they have to provide a written report with photos. So what the attorneys have told us, that is, if Cousin Eddie is a handyman by trade, it probably makes sense that Cousin Eddie might do your inspection for you. If Cousin Eddie's an accountant, it doesn't mean that he can't. It just means he's still gonna have to give us a written report with photos. So why don't you get somebody that actually is qualified to do this particular job? If there's any damage caused by any of the buyer's inspections, they agree to immediately repair any damage to the property and hold the seller harmless about anything that comes out of even their inspector being hurt on the property. All right, property data, the get out of jail free paragraph. Within blank days, and they've just added this, insert NA if not applicable, otherwise 5 days. So I've been training that the lower this number is, the better your offer looks. If I get 2 offers side by side and one has 5 days and one has 3 days, I'm going to move with the one with 3 days. If one has 5 days and one has 0, I'm going to move with the 1 0. So NA and 0 are going to say the same thing, but don't leave it. Well, if you leave it blank, it automatically defaults to 5. And what I don't like about this is the buyer may review additional data regarding the property, including but not limited to zoning, regulations, taxes, school district, square footage, land improvements, sex offenders, other convicted criminals, etc. But these are the magic words right here, including but not limited to. My example for this one is I got a client in California, calls me, says, hey, I want to go look at that house at 123 Main Street. I'll be on Friday. I'm like, you know what? I got time this afternoon. I go and I give him a video walkthrough of the property. He says, I love it. Let's write an offer today. So I leave my property data, maybe at 3 days, maybe at 5, whatever, because I know I want to make sure the client has a chance to come in and review this property. You can also do a sight unseen writer, but the same thing applies here. And so I fly to, or I go to the airport on Friday. I pick my client up. We drive to the front of the house. He goes, nope, not buying this house. What? Nope, not buying this house. How come? Because it's got a fire hydrant in the front yard. And I had a terrible experience with the fire hydrant. They dropped the ladder on my house. They cracked the windshield on me, whatever it was. I'm actually, this is a made up example, so don't freak out on me. Sure, eyes just got really big. Oh my God, really? So, you know, but truly it's including but not limited to. They can get out for any stinking reason they want to. So if you did this walkthrough, he's like, nope, I wanted a sodded yard, not a seeded yard, including but not limited to any stinking reason. So the moral of the story is the lower this number is, the better your offer looks to anyone. Buyer may have buyer's option expense of paying written inspection reports of the condition of the property reasonably deemed necessary by the buyer or its lender, including but not limited to. What does that mean? Your buyer can expect anything on that property they want to, and don't let anybody tell you that they can't. Please note also the cost of availability of insurance should be ascertained during the inspection period, including but not limited to homeowners and flood insurance. So we've got our inspection set up. We have sent our inspector out, and we've got 10 days by default to get our inspector to the property and get a report back to us and us send our inspection notice. I'm going to tell you to make this 15 days, and I'm pretty sure everyone else makes it 15 days as well. 2 weeks is plenty of time to get the inspector out there, get the notice back, and know what's going on. And I can inspect anything I want to on that property. And everyone has agreed to, as signing this contract, an additional 5 days if we need a specialist. So my general inspector goes out in my first 15 days and sends me a report. And the report says, on the roof, significant granular loss, possible hail damage, suggests inspection by qualified roofing inspector. If you can get that done in the original 15 days, just do it and get it done. If you can't, then you can send the cleverly titled notice for additional time for specialist report notice to the other agent saying we're exercising our additional 5 days. That is best practice. As your broker, that is what I should preach to you as best practice. I will also tell you, if you send me an email that says, hey, we're exercising our additional 5 days for specialists to get a roofer out there, I'm just going to respond and say, okay, great. Because all that notice does, it's just your buyer's signature and you send it to me. There's nothing for my seller to respond to. You're just giving us notice and we've already agreed to it. But I'll also tell you, if you send me notice that you're going to want additional time for a specialist, when you send me your inspection notice, there better be a specialist report along with that. Because this isn't just an additional 5 days because you and your buyer got behind, didn't have a chance to meet. Oh, we'll just exercise our additional 5 days and we'll send them our notice whenever we want to. If you need to do that, then you extend the inspection period and then send me your inspection notice in a timely fashion. And also, please note in big, bold, black letters, buyer may submit only one inspection notice. It must include all matters unacceptable to the buyer and a copy of all relevant portions of the inspection and specialist reports. Buyer may not object to anything that is not an inspection or specialist report. So on this note, take note of the property when you're walking through it with your client. If the front window seal has broken and the window's all fogged up, put that in your special agreements or your offer, front window seal to be replaced. You know, window fog to be removed, front window, to whatever that is. If you can see it with your own eyes when you walk through the property, put it on your offer. Because odds are the inspector would put that on his report. But if he didn't put that on his report, you can't ask to have that window fixed now. So I'd rather get it asked for up front if I can see it. Now, I don't expect you to go open every door, turn every doorknob, turn on every faucet. But if I can see that there's a giant crack in the wall and they're going to want that fixed, I'm going to make a note of it in my offer. So we've sent our inspector out, maybe our specialist out. We've got everything back. And now we've got 3 options to tell the seller. Hey, the house is great. We don't need anything fixed. We're ready to close. Hey, the house isn't great. We want some things fixed. If you fix them, then we'll close. Or, hey, the house isn't great. We want out. Those are your 3 options up to line 173. If you check, ooh, they moved me down. It used to be 174. Now it's 175. If you check this box at 175, you have effectively erased line 173. Because now you have to either say I'm satisfied with everything, or you have to send me an inspection notice. You can't just unilaterally leave the contract. So again, apples to apples conversation. If you send me a $100,000 offer with the limitation box checked, and I get another $100,000 offer with the limitation box that's not checked, I'm probably going to go with yours, because it's one less opportunity for your client just to pull up anchor and leave the contract. You got to give my seller an opportunity to try to make you happy and hold the deal together. Okay. So we send our inspection notice to the seller. We've checked by, we sent you done box 2. We've sent them our inspection notice. Then we've got 10 days as a collective unit to get on the same page about who's going to fix it and who's going to pay for it. So it says that who's going to fix it down, or who's going to complete and pay for the correction. I'm going to back up the truck just a little bit. When you make your inspection notice, let's suppose that we did have to send a roofing specialist out there. I'm going to tell ABC Roofing, write me up a bid for exactly what needs to be done. And then on my inspection notice, roof to be repaired or replaced as per attached ABC Roofing bid. And then it becomes part of the contract. And I don't know if it's 9 times out of 10, but I would tell you a majority of the time on a lot of repairs, the seller will just go with whomever you have suggested, because it's one less thing they have to worry about. They just got to get the person in there, get it fixed, pay them the bill, and move on. They're ready to sell their house and they don't care. So don't be afraid to ask for, Joe's handyman service to fix the GFCIs in the kitchen. The seller doesn't have to agree to it. But again, a lot of times they'll just say, okay, if you've got somebody that'll fix it, that's one less thing we got to worry about. I'm putting that in my actual inspection notice. Whenever I send them, I want the plumbing repaired by Joe's Plumbing Service, plumbing as per section 123 of inspection notice to be repaired by Joe's Plumbing as per attached bid. And if you can get bids from those people to send with your inspection notice, almost 10 out of 10, you'll get it done. Because then they know we're not waiting on a bid. So we've got those 10 days to figure out who's going to pay for it, or if there's going to be a monetary adjustment at closing. And we talked about this in team meeting this morning, that at any point in time, we send the inspection notice, seller sends a response. We're like, no, that's not good enough. The seller's like, oh, here's all we'll do. At any point during that volley back and forth, the seller can throw their hands up in the air and say, okay, fine, we'll fix everything on your original inspection notice. Or at any point during that volley, the buyer can throw their hands up in the air and say, we'll take the property as is. We just want to move forward. Also, if we volley back and forth for 10 days and don't get on the same page, the contract terminates. But once again, your buyer's got that, he's got another chance to raise his hand and say, up to 2 days after, we'll take the property as is, and not negotiate that anymore. Also, please note, if you do get a monetary adjustment from the seller, hey, we just want to pay you $2,500 instead of fixing this stuff, make sure you talk to the lender, because sometimes they can't receive that in a certain fashion. It's going to have to be off the sales price. It's going to have to be in concessions. Sometimes the lender wants that a specific way, so it passes through underwriting the correct way. Paragraph F, you can just skip it because it does not apply to us. Broker role. I'm going to do everything I can to assist and help you. I am not going to make any decisions for you. All the inspections and warranties are the sole responsibility of you. I'm happy to choose those people for you, but this is your responsibility. Sorry, I'm happy to contact those people for you, but you're going to choose them, because you're going to hold me harmless if there's anything that arises negatively out of this deal, provided one of 3 things didn't happen. The statement that steered you wrong wasn't made by me or one of my people. The statement or action that steered you wrong wasn't made by me, or the fact that I told you you had to hire ABC Roofing and ABC Roofing was the issue. Or 3, that I knew something was wrong and I withheld it from you. So let's suppose I sold a house 10 years ago and I know in the basement there is a giant 4-inch crack in the foundation that was never fixed. And then 10 years later down the road, I've got a buyer that goes in there and we write an offer. And right now there's a gorgeous oak bookcase all down that wall in the basement. So guess what? Buyer didn't see there's a giant crack behind the wall. Seller didn't disclose there's a giant crack behind the wall. Inspector didn't see it. Appraiser didn't see it. So technically I'm the only one that the seller may know about it. It may have been even, it could have been somebody before them, but technically I'm the only one in the transaction that knows about it. If there is, you know, our 7th 100-year flood in 10 years and the basement floods and it's found out there's a giant crack back there, and they go back to see that I had the listing 10 years ago, and they look at my pictures on the MLS and they see that I knew about it, guess who's liable now? And guess who's going to be paying to fix all that stuff? So if you know about it, disclose it. But the main thing is just make sure that you're not misleading them, that you're not forcing them to use someone specific. And then if you know something, you're disclosing it. Home warranty, either the seller's not giving one, the buyer wants one, or the seller already has one in place. I'm not going to bore you too much with the next 2 paragraphs, but this paragraph here essentially is what happens if we have a dispute over earnest money. The escrow either has to have a signed agreement by all parties, there can be a civil action filed, there can be a court order filed, or whatever may happen by law. Also, it could be go up to the state treasurer for 365 days. It can sit there. It's just, everybody wants it and nobody wants to let go of it. Escrow agent is not. Oh, so if it's not a real estate broker, then they've got to receive all the same things too. Lost condemnation. So I've got a fire in the house, or I have a tornado or a flood or whatever. It doesn't mean that the contract immediately dies. There are ways to get around it. And again, I'm not going to bore you with all the legalese in this, but they can proceed with the transaction and take all the insurance proceeds. They can pause the transaction and have the seller fix the house with the proceeds. They can take a reduction in the sales price because there aren't any insurance proceeds. They can terminate the contract. So there's options there if something happens, a kitchen fire or a flood or anything like that. There are ways to make that get done and still hold the deal together and or get your client out. And if it terminates based on that, they get their earnest money back and go back to point 0. Adjustments and closing costs. We talked about these on page 1. These are the things your buyer is going to be responsible for. These are the things the seller is. And then these are the things we're going to split 50-50. Well, not 50-50, but we're going to prorate based on the time of the year. When everyone signs this contract, everyone is agreeing to a 1031 exchange if the seller chooses to use their funds that way. This does not affect the buyer at all. I don't even think the buyer has an extra piece of paper that they have to do. They just have to understand that the seller's funds may be escrowed for a while for them to identify a property to go 1031 their money, okay? This entire agreement, again, if it's not in the 4 corners, it does not exist, and this contract may not be changed, modified, amended in whole or in part, except by writing signed by all parties. Default and remedies. Hopefully we won't have these conversations, but there's a decent chance we might. We got a ready, willing, and able buyer. We had a ready, willing, and able seller. Seller gets a phone call today that says, hey, that job in Tulsa that we were going to move you to next week just evaporated. We're not moving you down here. Sorry, good luck. Seller says, oh crap. Fortunately, we haven't bought a house in Tulsa yet, but we're not going to sell this house. Buyer's agent calls, says, well, you're under contract. You got it. Well, we're not showing up on Friday. So seller has defaulted. Buyer has 3 options. Well, truly, buyer has what I like to call 2 and or a 3rd option. They can sue the seller for performance, make them sell them the house. They can mutually release the property, and then the buyer is entitled to all of their expenses back. So they get their earnest money back. If they've done a title search, they get that back. If they've done an inspection, they get those fees back. Survey, any real expenses that they've had, they recoup. And then it says, or 3, pursue any remedy damages available by law. I truly believe it should say and or 3, because just because you send me a mutual release does not mean that you won't sue me. I'm smart enough to know that. So just bear in mind that we don't want them to default if they can keep from it. Similar scenario, buyer was supposed to move here and close Friday. Buyer's job evaporated. Buyer's not going to be here, so buyer defaults. Same 3 scenarios with a slight exception. Seller can sue them and make them perform and buy the house. Seller can mutually release them, but only retains the earnest money. Seller does not get any of their expenses back because the contract sees all of their title fees and all of those expenses will be recouped eventually in the sale of the property. So they don't recoup those. And then again, and or 3, pursue any law available. And if there is litigation and someone does have to sue, prevailing party is going to get their reasonable attorney fees paid. Seller's disclosure statement, either I got one, I want one, or the seller's not providing one. I always try to look at a seller's disclosure statement before I go to property, if at all possible. You know, let's suppose the listing went live this morning and I was going at noon today to look at the property and they're not on the MLS yet. I'm just going to reach out to the agent real quick and say, hey, I see your seller's disclosures aren't up yet. And I guess it's lead-based paint. MLS changed something now. You can't get fined for lead-based paint because you cannot submit it without that being on there. But seller's disclosure, sometimes they're not up immediately. Hey, will you send me a quick copy of those? Seller also indicates that they're going to fully and promptly disclose in writing any new information pertaining to the property made known to the seller prior to closing. So if you've got a property that you're making an offer on and you know that it's already been under contract and fallen out and the seller's disclosures are exactly as they were before, I might reach out to that agent and say, hey, did you guys get an inspection? Anything you need to disclose that wasn't disclosed in those disclosures? It's a lot of disclose there right in a row. And also just real quick to show you guys something in case you ever get this pushed back at you. You get an agent on the other side that says, well, I don't have to show you those, anything that happened from previous inspections. You bring them, if they use the Missouri Sellers Exclusive Agency Agreement, it states right here, owner firmly agrees to promptly furnish realtor with all inspection reports, if any, regarding the property, and authorizes realtor to disclose and provide such reports to prospects. So, Mr. Seller's agent, if you are under a Missouri employment agreement, your owner's already given you permission to send me those inspection reports. And also, you're supposed to update your seller's disclosures with any new information that you have. Most of them are pretty good about updating it if something's gone south, but just be mindful of that if the property's already gone on and off the market, that there might be things that they know about that property that they're not disclosing. Adjustments, closing costs, 1031, seller defaults, seller's disclosure. If it's required by law, there'll be a lead-based paint attached. Okay, walkthroughs and utilities. You've got the right to do a walkthrough to make sure the property's in the same condition and to make sure that repairs were made. I see those as two separate events, depending on what kind of repairs you had done. If I had a bunch of repairs done, if I had an electrical repair or a plumbing repair, something that's a major functional item, odds are I'm going to try to talk my buyer into doing a re-inspect just on those specific items. And I want that quote walkthrough or re-inspection done as far away from closing as possible. So if something's not right, we've got time to fix it. So you don't call me at noon on a Wednesday and say, hey, I've got a closing at 2. We just did our walkthrough and X, Y, and Z isn't done. We can still figure that out, but I can promise you it's a lot easier to do it 2 weeks out than it is 2 hours out. And then you've got a chance to do a walkthrough to verify the property condition for your buyer, that everything is as it is before they close. I try to do that as close to closing as possible. And I really try to encourage my buyers to go to that as well. And if my buyers can't go to a walkthrough, what do, Maria? There it is. You go for them. And I truly do, because I want to put my eyes on it, because I've dealt with bank foreclosure properties where you walk through and they were supposed to be out and the property was vacant, and I walk in and all the appliances are gone. Or, oh, somebody came in last night and stole all the copper out of the walls. So I try to check those things for my client, even if they don't want to go, because I want to make sure when they sign their name on that dotted line, they know exactly what they're getting, because once they sign, whatever's in that house, no copper, that's all their problem now. Signature, same thing with our employment agreement. You can sign this anywhere and it's valid in the state of Missouri. Mr. and Mrs. Buyer and or seller, I'm going to follow everything. It can be plural, masculine, it's gender neutral on all this. I'm going to follow the government law. I'm not going to break the law for you. Notices. Any notice, consent, approval, request, objection, communication, collector required under this contract to be delivered to seller shall be in writing and shall be deemed delivered to seller upon delivery to the broker. And this is a two-way street. Delivery to the agent is delivery to the client. I should expect reasonably that if I send you an email with an offer, it's the same as I send it directly to your client. And you should have the same expectation of me. I will tell you, you will be disappointed, because not everybody operates that way. But that should be your reasonable expectation. And if you get somebody really pushing back on you, well, line 385 to 387 on the contract says you're going to give this to the seller as quickly as possible, and you've not done that. What's the reason for that? Don't be afraid to push back. But again, the buyer, both sides of the street should expect the same thing of each side. If you've got any special riders that go on here, if I'm doing a warranty, I will actually attach the put the A on it. George, be mad at you. And then I fill out the warranty form and I attach it and it becomes part of the contract. So the seller knows exactly what the expectations of the buyer are. And then again, guess what? All they have to do, fax that form in and they're done. They don't have to fill that out for me. Special agreements. I'm just going to tell you about this a minute ago. Paragraphs PHS 5 and 6 to carry through to closing. That's your appraisal and your title, not your inspections, because your inspections should be done anyway, but that's your appraisal and your title. So if there is an issue that we have to extend that's your appraisal and your financing. So if there's an issue that we have to extend the contract, all of those timeframes are automatically extended for you. So I don't think that's a bad idea. I know a lot of the big teams are doing that just to ease that problem if it comes up, so I don't have to worry about remembering to extend all my timeframes. And this also, and this is true of anywhere, and I should have told you this on page 1 on exclusions and exclusions. Let's suppose for some reason we had a bunch of things, that special agreements that we had to write in here, and I don't have room to fit them all in here, or I don't have room to fit them. We'll just go back to the inclusions. So let's suppose I wanted 17 things included in this property and there's not enough room. I'm just going to put C attached exhibit A, and then I'm going to go create a Word document called exhibit A, and I'll write all my terms on that. And then my buyer signs off on that, seller signs. And once again, it becomes part of the 4 corners of the contract. Okay. And you can do that in any document that there is. If you don't have room to write something, you can do an attachment with an exhibit. Writers, special agreements. If you have a personal interest in the property, are you part of the transaction? Do you have ownership in it? Or are you representing an immediate family member, which is parents, children, and siblings? True on both sides if you're married, but I honestly, personally disclose cousins, aunts, uncles. I don't see any reason not to, because I don't want it to ever be an issue 3 days before closing. You didn't tell me you're selling this to your cousin Ashley. A, what difference does it make? But B, I don't want it to make a difference. So I'm going to disclose that to you up front. Disclose, disclose, disclose. All right, broker compensation. If you are not collecting a transaction fee and you had a 3% commission in your buyer's agency agreement, and there was a 3% commission being offered in the MLS, then your compensation is coming from the seller. If you have a transaction fee, we already know based on section 10 that the seller cannot pay that transaction fee for your buyer. So you're getting commission from the seller and a transaction fee from the buyer. If you're not charging a transaction fee, you have a 3% agreement with your buyer's agent. MLS is only offering a 2.5%. Your buyer has agreed to make up that difference. I'm getting compensation for both the seller and the buyer. Okay. Brokerage relationship. You'll be a buyer's limited agent, also serving as a designated agent. KW, our license number here, your signature, printed name, license number, date. If we were just letting you know, if we're part of a franchise, you can only sue us. All your sales information is going to be given to our board and our MLS unless you give us in writing that you don't want us to. If there's any doubt whether or not your individual can purchase and or sell the property, you can go to the FERPTA website, but they need to be either a, where is it, citizen or resident alien. I'll make sure that I actually tell that to you right. Well, it's in here, unless they've taken it out. Foreign person must. Anyway, your folks will know if they're able to buy. If they don't have a social security number, they're not going to be able to purchase the property. Anti-terrorism, just don't sell to terrorists. Accepted deadline and effective date. You do not have to have an expiration date in order for your contract to be valid. You do have to have a end date, but you don't have to have an expiration date for the offer in order for it to be valid. And to me, this is a lot like the earnest money conversation. It's a case-by-case scenario. If I know I'm going to have a lot of competition, I might call the agent, say, hey, I'm sending you an offer today. When are you guys going to review these? Because I want to make sure my expiration time period is still there, but I want to have it as soon as possible. Or if we know they've already posted on the MLS and the agent only remarks, reviewing all offers Friday night at 5 p.m. Well, I'm going to make my expiration after that if I want to know that. Because if it truly, if I put 5 o'clock today and they reviewed them at 7 o'clock tonight, my offer is no longer valid. And normally I try to give, if I made an offer today at 2 o'clock, I'm probably going to try to give you maybe till 5 tomorrow, probably at least till noon. I try to give you at least close to 24 hours. But let's suppose I had a client in town today and we've got 2 houses to look at. And this is the only time they're going to be able to be in town again until their job starts in May, March, whenever. So we've got to buy a house today. So we go look at house number 1 at noon. They love it. They want to make an offer. But if we don't get it done, then we got to buy the other one today. So I'm going to type up my offer and I'm going to put a 6 p.m. expiration on it. And then I'm going to pick up that phone and call the other agent, say, hey, I know that this is a 4-hour expiration. I know that's crazy. Here's the situation. We've got to buy something today. So I tried to give you till after work, so hopefully you could talk to your clients, but we've got to have an answer, because if your answer is no or no answer by 6 o'clock, we're moving on to this other. So if there's a reason for a short time period, I call and explain why that is, because I don't want to piss off the other agent just because they think I'm trying to sneak in underneath somebody else. Time is of the essence. A day is determined as a 24-hour calendar day, 7 days per week, weekends, holidays included. Also, if you make your offer and your offer is accepted today, today is day 0. As of 12:01, what is it today? Wednesday, 12:01 Thursday morning, that is day 1. So if you got your offer accepted at 12:01 a.m. last night, you got a full free day. Does that make sense? Okay. Time is of the essence. If you need extra signatures, buyer signature, printed name, the date. Also, if you do have this is an important note. If you've got an actual expiration time period in here, you need to actually come in and write the time that this was signed. Our DocuSign, for whatever reason, does not actually put the time. Dotloop used to do that, DocuSign doesn't. So if you have an expiration that it's going to expire by 5 p.m. on today, I've got to know what time that was actually signed in order for it to still be valid. Because same example, if mine expired at 5, they signed it at 7, technically my contract was no longer valid. So we got to know what time those are actually signed. If you've got a LLC or legal entity, you can put the name here and what the titles and who are signing it. If the seller accepts, they sign. If they counter or reject, they initial off here. Okay, questions about the contract? I got some other docs to show you. I kind of blasted through that, but I think you guys know what's going on at this point. I'm trying to think if there's any else specifics that changed today that I need to tell you about. The inspection things, most of it was just language in the inspections, as far as, let me just look real quick, make sure I'm not missing anything specific. No, this NA was the main thing in the inspections that they put in. And again, I don't know that that was really necessary, but they didn't call and ask me. So, all right, so we've written our contract and we've gotten our inspections done. Now what do? Well, we fill out this fantastic little inspection notice here. City, zip, county, street address, to the seller's name, from the buyer. And here's our 3 options. Buyer satisfied, buyer's not satisfied and wants the following things fixed, or buyer is going to terminate the contract. Again, if I check that box at line 175, I can no longer do this down here. And this is another example of where you might have to use see attached exhibit, whatever. And I think we're going to do, I think it's next month, we're actually going to do an inspections class on the best way to write an inspection notice, or at least the way we would, several of us would suggest you do it to make sure you're getting exactly what you want done for your client. I don't think that got on this month because of Ignite, but if not, I'll make sure it's on next month. But this is where you'll list all your items for that. If you don't have room, again, do a see attached. Buyer signs off, and then seller's got the options. Either they will fix everything, they're not going to fix everything, so the contract terminates, or we're going to make a counter proposal. So yeah, we're good. No, we're out. Or hey, here's our counter offer to you. And if they counter offer us under the cleverly titled inspection notice response, then these just bounce back and forth. As I was talking about that volley, they'll send us 1 and we can send them back 2 and 3 and 4 and all that on and on. And it's like, who's going to be the one that's responding? And if we were doing number 1, it would be the seller responding to us with the things that they're willing to do, or a monetary adjustment. And then the buyer's got the option to say, either we accept, we make a counter proposal, and note that these are in different orders than they were on the inspection notice, which I don't know why that is. So yeah, please capitulate at part CELO or sign. Oh, okay. Does not accept, and they make a counter proposal, or they don't accept and the contract terminates. Or if they have chosen at any point in time during this volley back and forth That's when they come down here to this part C and just say, you know what, I wave my hands up in the air, we'll just take it as is, or I wave my hands in the air, we'll sell it and fix all of your items that you have requested in your original. We talked about this morning. I don't think you guys will run into this a whole lot, but if you've got a buyer that wants to do it, make an offer as is, this is a pretty good writer because it explains exactly what the expectations are. Number one says the buyer can do whatever inspections they want to. The buyer can still walk away from the property, but the seller's clearly not going to fix anything. Number two says the buyer can do whatever inspections I want to. The buyer cannot walk away, but the seller's still not going to fix anything. And then C3 says buyer's not going to do any inspections, can't walk away, and we know the seller's not going to fix jack squat. I'll show you this one real quick too. Oh, let me show you the other one first. I don't like the way these are titled because I think it's misleading. So if I've got a buyer that wants to make an offer on a house, they're willing to sell their house, but either we don't have it on the market yet or we don't have a contract. This is the document that you use for that. You put the street address and everything, and it's contingent upon the sale of the buyer's existing property located at whatever the buyer's address is, and closing on or before X. And this is probably what I get the most questions about this document. Well, Don, we don't even have a contract on the property. We may not even have it listed. How are we going to know when it's going to close? All right, well, hopefully the property that your buyer is purchasing, our goal is to close it in 45 quote unquote standard days. So your goal with your buyer needs to have their house under contract in 2 weeks. Because to me, that's a nice round number. I go from 45 to 60 days. So I would just make this 60 days from now. So this would be 3, 4, 20, 23. Because we can extend this if we need to, but I present it that way because I want some fire underneath my buyer's feet to know if we're going to do this, we got to get your house under contract. Because guess what? If we don't, at any point in time, the seller can give us 72 hours called a kickout notice saying that they're going to terminate the contract. And please note, nowhere in here does it say that the seller has to have an offer or a better offer in order to do that. They can just terminate it if they choose to do so. So just make sure that the buyer knows we need to get this sold as quickly as possible. And then if they waive the contingency on the document, another document I'll show you here in just a second, they haven't waived their financing, but they've essentially waived the ability for the lender to say the property didn't close and now we can't finance the property. Here, the time frames 5, 6, and 7 of the contract shall begin as of the date of the buyer delivers the notice to the seller. So you can go ahead and write the contract, have it accepted today. We've got potentially 2 weeks to get my client under contract. Once my client gets under contract and I send notice to the seller, then my time frames begin at day 0 with the the one the buyer is purchasing. Where's the other one? This is it. Yes, this is it. So this is the notice from the buyer. Pursuant to the above agreement, contract notify the buyer became under property to sell on blank date. Hopefully whatever date that we've already indicated, 60 days out. We've got a contract on the property and it's going to close on this date. Buyer's notice to the seller. This is seller's notice to the buyer that we are giving you a 72-hour notice on your kickout. So you either need to perform or not. If the buyer comes down here and says, we'll waive our contingency for the sale of our property, you've also waived, where's it in? Buyer remains obligated to close on the contract, even if the buyer's existing property fails to close. So if they sign down here to say, we're going to waive our kickout, or we're going to waive our contingency, they've got to have the funds to close on the property, regardless of whether or not their home sells. Now, if I give notice up here that I've got my property under contract, you will get pushback from other agents about this. I promise you, but I think this is best practice. When we originally sent it, we sent it under this contingency for sale, saying, I don't have a contract on my property. I'm going to get one and so forth. But I'm going to come in and I'm going to now change it to my contingency for close. Because once again, this is what protects my buyer. Attached to the property located that we're purchasing, the contract dated at the buyer's address, it's going to close on or before. whether or not it's contingent upon another property. So what this does, if the closing of such sale is not or will not be timely completed through no fault of the buyer, so not the buyer, but the person buying the buyer's home, if something happens with them, then the contract shall terminate at my buyer's option at sending notice. So it keeps my buyer from being hooked in if their property fails to close because of someone else's fault. So to me, I'm going to tell you to use this one because I think it is the best practice to keep your folks protected. Counter offer is pretty straightforward. It bounces back and forth just like the other one does. You can change specific terms if you just got price or concessions. We talked about the get out of jail free paragraph, that if you left it blank and it had 5, you might get section 7 line, well, I can't what that one is, 134 blank changed to 0 days. So you'll see some of that sometimes, or if you've just got other terms down here you need to change. And I would tell you, I always put an expiration on my counteroffer. I try not to make it unreasonable, but we're already in negotiations, so let's not drag our feet. Let's get this figured out and move on down the road. COVID, I don't worry about anymore. Done that one. Oh, I was going to show you this one too. And this looks very similar to the conventional financing section in the actual contract. Contract ability to same a government guaranteed loan, the amount of whatever percentage price or the actual purchase price with the number of years not to exceed. And a lot of times I will also put TBD in those, and then down here put all terms to be determined by lender. The thing that they have changed in this document, and you guys may not have been around long enough or even know that this was a thing, VA didn't used to allow their purchasers to pay for repairs to bring the house up to their standards. They have since changed that because I know sometimes sellers now are digging their feet in and saying, we're not going to fix anything else. And then the buyer loses the house. So they're now giving the buyer the opportunity, providing it doesn't change their debt to equity ratio, to go ahead and pay for those repairs so they can get into the property. So that was the big change on this document. But what kind of actual loan are we doing here? The property and the loan are no less than the value of whatever your offer price is here, just to make sure that it's covered all the way across the board. Again, this is another one I like to put all terms to be determined by lender, just because I don't like giving out this information if I don't have to. This is another one, carry this through to closing. It's just like the 25 days in the regular conventional. Inspection notice we did, response we did, we don't need that one. You'll get this a lot of times will be attached with your seller's disclosure, or if you're representing a seller, it's just indicating where the seller got their actual square footage numbers from. And we have to sign off on that. That is a compliance item now. All right, all those other ones say seller. What questions have you guys got? Just enthralled with all the.
I have one. So somebody I know who was going to be a buyer in a couple of weeks and wanted a new build, and we're dead set on that. Well, I'm like, okay, it's almost time where you can get your home. He goes, found out my brother's a builder and he gave me an offer I can't refuse. So I'm still waiting to find out if he needs me, but I wonder at what point they would get an address for that, or what type of document would be needed. It could be that contingency one.
Yeah, that's just gonna be more of an item. You're gonna have to communicate with him to find out what the status of the house is, if they're planning to list it and those kinds of things. But yeah, I would offer to help and just say, you know, I'm happy to facilitate the paperwork. My guess is his brother, whoever it was, probably has their own builder's contract and knows what they're doing. But you can also offer, if you would like me or my broker to look over that contract to make sure that you're actually protected, come from contribution, I'm happy to do that for you. If you want to send it to us before you sign off to make sure all of your I's are dotted and T's are crossed, just let us know. I'm happy to do that. It'll take me 20 minutes to look at a contract. Anything else, guys? I don't know if there's anybody even online. Oh, Christy's back. I hope you can hear me this time. Do you need anything? You got any questions? Either unmute or throw it in the chat box if you do. Or maybe your computer's just been on all day and you're not even here. I don't know. No, no mute, no chat. So, all right, gang, that's what I got for you today. Live long and prosper. Call me with questions.
Thank you, sir.
And as Shannon mentioned this morning, I'm also happy at any point you guys have, if you got one that you're sending out, or if you want to do a practice contract or whatever, just let me know. I've got that. Again, it doesn't take me more than 15 or 20 minutes to read a whole contract, stem to stern. Be awesome, guys.